Hello again, I'm attorney Robert Flessis for Robbins & Lloyd Career Training Institute. This video is part 3 of course number 1 on agency law. I'm going to discuss the creation and termination of agency, but I'm going to start with multiple representation relationships and designated agency. Let's get started. Wisconsin Statute 452.134 governs agency relationships. This statute tells us that an agency relationship is not required and a broker may provide brokerage services to any person in a transaction. A broker is not required to have an agency agreement with a party to a transaction, but a broker is prohibited from negotiating on behalf of a party unless that party is the broker's client or the client of a sub-agent. So how does multiple representation play into this? Well, multiple representation occurs when a firm represents both a buyer and a seller when dealing in the same transaction, and both parties are the firm's clients. For the broker to represent both parties that are under contract as clients, the broker must have the written consent from both parties to authorize designated agency. If the broker has the written consent of both parties to the transaction, then it's the broker's obligation to then designate different agents within their firm to represent each party. If the broker doesn't have the written consent of even one of the parties, then the broker and its agents may not place the interest of any of those two clients ahead of the other in the negotiations. The agents must remain what? Neutral. Now remember, clients who consent to designated agency can also withdraw that consent in writing. A client designates their multiple representation relationship preference on approved forms where the client selects one of 3 boxes. The first box allows designated agency if the same agent doesn't represent both parties. This is multiple representation with designated agency. The second box authorizes the firm to represent both parties, but requires the firm to be neutral. This is multiple representation without designated agency. And the third box does not authorize multiple representation at all. The client, by checking this box, rejects multiple representation relationships completely. The firm may not represent this client or the other client in the transaction. Now I want to tell you about an actual disciplinary action against a licensee and broker who violated this statute. A salesperson represented a seller. The listing contract indicated the seller agreed to multiple representation with designated agency. Now, based upon what I just described to you, what does that mean? It means that the firm is required to designate separate agents within the firm to act as a buyer agent and a different agent to act as the seller's agent. In this example, the salesperson was working as both the listing agent and was working with the buyer. Here are the facts. A buyer was interested in one of the firm's listed properties, and the listing agent and buyer were exchanging text messages. The buyer wanted to make an offer and said that they were fine with the listing agent acting as a dual agent, meaning that the listing agent could work for both the seller and this buyer. Sounds as if the buyer was confused, right? This is the point in time where the listing agent should have taken the time to fully explain how multiple representation relationships operate. The salesperson should have at this point discussed agency with the buyer before proceeding with the offer. But he didn't, because what do you think was central in the listing agent's mind? He was more interested in his commission. He didn't perform his statutory duty to explain agency to this buyer. He just blew right past that requirement. So the buyer offered a price and the listing agent said that he would draft the offer. But there was a delay in the drafting of the offer. So the buyer, after a few weeks, contacted the listing agent to inquire about the delay. Well, the buyer stated to the listing agent that he thought there was a deal and then said, when you're a dual agent, you need to fairly represent me too. That's probably true. The buyer was under the impression that he was a client, though, not a customer. The listing agent responded that the delay was due to the property generating more showings and the seller was waiting for more offers. Well, let's stop again. Is that the way you deal with a buyer that wants to write an offer? No, you can't drag your feet. Well, 2 weeks later, the buyer signed the offer drafted by the listing agent. So it took this listing agent, again, 2 weeks to finally prepare and present the offer to the seller. Here's the problem with this situation. The offer indicated that the listing agent was an agent of the buyer, even though he had a listing contract with the seller. The buyer also signed a disclosure to customers which stated that the listing agent was the seller's agent and not the buyer's agent. Well, we have conflicting versions here. The listing agent signed the listing contract and the seller then became what? His client. Why in the world would this salesperson indicate in the offer that he was also the agent of the buyer? Well, let's break it down. This listing agent is presenting an offer to his client, the seller. Second, he's indicating at lines 1 and 2 of the offer to purchase that he's the agent of the buyer. Do you think that the seller even noticed that? The offer was accepted by the seller and the contingencies began to run. After the inspection, the buyer sent a list of 31 items from the home inspection report to the seller through the listing agent. The salesperson who received the report emailed the seller as follows. Below is his laundry list of repairs. Not too happy with it. Let's discuss. I'm of the mind to tell him we aren't interested in repairing anything since we came down in price so much. Gather your thoughts and let me know. Let's stop right here. The listing agent isn't presenting this offer properly to the seller. What should this listing agent have done before contacting the seller? He should have been checking the definition of defects that's in the boilerplate language of the offer. That way, he could determine after we reviewed the inspection report what qualified as a defect. Then, he could consult with the seller knowledgeably. Back to the story. After learning about the response from the listing agent to the buyer's list of defects, the buyer contacted the listing agent's managing broker to express the buyer's concerns regarding this listing agent. Well, the listing agent prepared a WB-40 amendment to offer to purchase, which stated, buyer acknowledges that the listing agent and the brokerage firm assisted buyer as a customer, not a client, as disclosed in the disclosure to customers signed by buyer. Isn't it a little too late for that? The buyer submits an offer, it's accepted, and the buyer is under the impression that he's being represented by the listing agent. The company is now trying to cover their tracks because they have an agent that doesn't know the rules, and apparently neither does the supervising broker. Well, the amendment also stated, buyer hereby waives any claims against the listing agent or the firm and shall agree not to file any actions or complaints with the Wisconsin Real Estate Examining Board, the National Association of Realtors, or civil or criminal actions related to this transaction. Well, can the broker make the buyer waive their right to complain to the board or even file a lawsuit? Absolutely not. You can't disclaim your liability. The listing agent didn't understand agency law. The supervising broker is trying to give cover to this agent's ignorance and attempt to protect the brokerage firm. Well, subsequently, the transaction closed, and of course, a complaint was filed by the buyer. The Real Estate Examining Board found the listing agent, the supervising broker, and the brokerage firm violated the statute by failing to provide brokerage services with reasonable skill and care. This means that all three of them screwed up on the agency disclosures in the offer. They confused the buyer. The REEB also found that the listing agent was in violation of the statute by failing to present the offer in an objective and unbiased manner and disclose the advantages and disadvantages through his comments to the seller. The REEB also found that the listing agent failed to use the approved forms and prepared addenda to adequately accomplish the instructions provided by the party for whom the form was drafted. The listing agent and broker were acting in their own interest to cover up their agency violations by handing the buyer an addendum to the offer in an attempt to limit their liability. The firm and listing agent should not have inserted this into an addendum to the offer. This was a disclosure issue. If they were going to amend the offer, then the addendum should have corrected lines 1 through 2 of the offer to correctly set forth agency. But they were too deep into the transaction at this point. Let's move on to how do you create agency. There are 2 requirements to create agency. First, the agreement must be in writing through a listing contract, buyer agency agreement, or leasing or management contract. Second, the agreement must be signed by the party. How does agency terminate? There are several ways. Termination can occur with the sale of the property, the expiration of the listing term, the death or incapacity of either party, by cancellation by one party, but that one party that canceled it could be liable for damages, by transfer of title to the property by operation of law. This includes bankruptcy and foreclosure, by mutual consent of the parties, by destruction of the property or change in property use like a zoning change, condemnation of the property, or eminent domain. The next question is, who has the power or the legal right to terminate agency? A seller nor the brokerage firm have a legal right to unilaterally terminate a listing contract. The unilateral termination of a listing contract can occur if one party materially breaches the contract. Agents of the firm can never terminate a listing contract unilaterally because the listing contract belongs to the firm, not the agent. And on this point, agents of the firm can't amend a commission amount or shorten a listing term without the authorization of the supervising broker. Well, what is the mechanism to terminate an agency agreement? The document that terminates the agency agreement must, of course, be in writing and delivered to the other party. Remember, delivery creates acceptance. The termination is effective upon delivery. Well, what about a cancellation agreement and mutual release? A cancellation agreement and mutual release is a very important document. When signed by the parties to the transaction, it waives all rights under a listing contract, including the right to assert listing protection of buyers. When a listing contract naturally expires and you're no longer authorized to list the property, your protected buyer's clause in the contract survives. Well, this concludes part 3 of agency law. Part 4 will be our review, and I'll see you there.